think I'm down to the last slide already, which is Rule 49.13. It says that despite these rules that we were just highlighting just now, the court, in exercising its discretion with respect to costs, may take into account any offer to settle made in writing, the date the offer was made, and the term of the offer. So I was just going to ask you to maybe explain to us the significance of this rule here with the discretion of the court.
So with an offer to settle, eventually the court will look at what offers were exchanged after the hearing on the merits of the matter. And they can look at any written offer to settle. Usually it's one that's in the form under the rules of civil procedure, but it doesn't have to be in the form that's provided by the rules of civil procedure forms on the internet. You can send it in an email, you can send it in a letter, you can, I guess theoretically, you can use a different form of communication in writing, like a fax, but it doesn't have to be in that exact Rule 59 perfect with a style of cause and the numbers underneath.
Yeah, this is particularly sort of relevant to a self-represented person's experience, I would say, because like a lot of self-reps, again, as I said in a previous video, they don't even realize that there are the rules of civil procedure. So they may not even be aware that there are all these rules that apply to an offer. So they could be offering to settle in good faith. And, you know, I'm just thinking that I imagine a judge would probably take into account the fact that they're a self-rep and they've made good faith offer to settle. But
yeah, the court has discretion.
Yeah.
They try to not deviate too far from the rules unless there is a special circumstance. So if you made an offer to settle in writing and it was open and it was made 7 days before, at least 7 days before the trial, and you beat your offer to settle, then usually the court will follow the default of awarding costs in the benefit of the party that beat their offer. In some cases, it doesn't go that way, but that's an exception. That's an extraordinary circumstance, and the court tries to be consistent with the rules, but they're not like married to them in the sense that they can't make a deviation or something from it. Exactly. The court wants to do what's the most just and fair outcome. And usually that's consistent with the rules, and they will not exercise their discretion to deviate far from what the rules are guiding them to do. But in special cases, they might say, you know, even though you beat your offer to settle, I'm not going to award you costs. And we've seen that in some motor vehicle cases with insurance companies that have beat their offer to settle, but they have still awarded the plaintiff their costs for the action.
That's really interesting. Well, thanks, Heather, for clearing that up for us. So to our viewers, thank you very much for watching. If you're new to our channel, don't forget to hit the subscribe button and also hit the bell so that you can be notified of our upcoming videos. And we do have one final video coming up for our series on costs, and that's assessment of costs, because I think that a lot of people don't realize that if you feel that your costs are kind of like, or if you feel that the cost of your opponent is sort of too high, you could get a special kind of assessment officer to take a look at it and to review it. Anyway, so that's going to be our next video. So don't forget to hit subscribe. Thank you very much for watching, and we'll see you in the next video. Bye-bye. Bye.
Bye.